That one. I'm going to share the screen.
Good morning.
Good morning.
Morning.
All right. Okay. Give me a thumbs up, Gary, if you see the screen. Good deal. All right. I figured it was time. This is one of the first trainings I did, I think, about over a year ago about ways to get out of contract terminations. We used two different forms. We used the seller's notice of termination, and we used the buyer's notice of termination. Stephanie, you have a question before we get started? Oh, thumbs up. Okay. Anyway, so I figured it was a good time to go over. We had a lot of questions. Hey, the buyer didn't do this. The seller didn't clean the house. The whatever. Can the buyer terminate? So I go, oh, let's cover what we can actually do based on the contract, and then the forms we use. And here's what we're doing. So anyway, first up, always a reminder as agents, right? We get this all the time from Trek, from our classes and so forth, that we're not attorneys, but we're licensed agents or brokers that are authorized to use the promulgated form. What does that mean? The forms prepared by attorneys at Trek or Texas Realtors or Houston Association of Realtors or ABOR or whatever. Basically, professionals that write legal copy for us to kind of fill in the blanks. Okay. That said, we are held accountable to know the forms. We're held accountable, the forms from Trek, the forms from Texas Realtors, basically all the forms that we may put into use for our clients. We have a duty to be aware of and to understand them. And then all the local jurisdiction disclosures, right? You know, your MUD forms, your PID forms, and that kind of stuff for where you do business. And that's why Trek is very big on our licensing being around our competency, a geographical competency, and of course, a area of expertise, the area of real estate that you work in. So a reminder there. And then, of course, we are held in Texas to the fiduciary level, which is akin to an attorney. When choosing which form to use, like which addendums to add to your contract, which contract to use for the type of property it is, utilizing the forms accurately, making sure they're complete and accurate. And then we're representing our clients when we advise them on inspections and roofing and that kind of stuff. And then when we refer them to other professionals, those are all at the higher level where literally we're held to the level of an attorney, the fiduciary level. Yes, Sharon, go ahead and mute yourself. And then so forth. So it's this kind of this weird thing as agents. We have to know a lot of legal stuff and operate at a legal level, and yet we can't be attorneys. We can't give legal advice. So we have to kind of thread that narrow line as agents, and that's why we constantly cover Legal 1, Legal 2, every renewal, just to make sure we're in compliance and know what our responsibilities are. So I just say that to start off what we're talking about today. We're talking about a lot of legal stuff in the contract. Tip is basically stay in our lane. You know, we're real estate agents. You know, we have this narrow lane where we can advise on, which we do a lot, but our job is to refer or send them or connect them with the information, the professionals, the county, the cities, in this case, attorneys, CPAs, inspectors, appraisers. That's why we use third-party professionals, because they're the professional. We're going to refer them off, then it's outside of our scope of practice. And so keep that in mind as we do this stuff. So a couple terms I wanted to cover today. Fiduciary, we learn this in the Code of Ethics. We learn this in our legal classes. But generally what it means is our responsibility and duties are ethical and legal. When a party knowingly accepts a fiduciary duty on behalf of another, they're required to act in the best interest of the defense of our clients. So once we sign a agency agreement with our client, we have to put their best interest first. As simple as that is, but some of those things that's where we get in trouble legally, because okay, did we put them first? Are we looking out for their best interests and so forth? In some states, it's a statutory duty, which means do no harm. It's a much lower bar. In Texas, it's a high bar. That said, breach of contract, we get this a lot. And so we hear about breach and we hear about default a lot in contracts, and they throw terms around. So I wanted just to cover breach. Just simply, it says a breach of contract occurs when one party fails to fulfill its obligations as specified in the legally binding agreement or contract. It means that not one or more parties involved in the contract fail to perform their duties, provide goods, or deliver services according to the terms and conditions laid out in the contract. When a breach of contract happens, the injured or aggrieved party may be entitled to seek remedies or damages for the losses they suffered as a result of the breach. Now, as said, there are different types of breaches. We're going to cover just two of them right now. There's the actual breach of contract when one of the parties completely fails to fulfill their contractual obligations or fails to perform them within a specified time frame. If the buyer doesn't complete the sale and close by the closing date, they've completely failed to fulfill their obligation. Or if a seller can't deliver a clean title and sell to the buyer to the property, they fail. So in this case, it's an actual breach of contract. So in this scenario, the breaching party's actions clearly demonstrate complete non-compliance with the terms of the contract. What we see a lot of, though, is a partial breach. A partial breach, also known as a minor breach, occurs when a party does not fully meet all the requirements of the contract, but still performs some of the aspects. It's a situation where the breaching party has not completely failed to perform, but has fallen short in some respect. It says a partial breach typically does not entitle the non-breaching party to terminate the contract, but may allow them to claim damages resulting from the breach. This is one of those cases where the house should be clean and it's not. This is one of those things where the seller had repairs and they didn't finish them according to the contract. They can't give the seller the right or the buyer the right to terminate because of it, but it gives them the right to pursue damages for not fulfilling all the terms of the contract. So make sure we're kind of getting the framework around these terminations. They're very specific around actions. We get a lot of calls from agents on both sides because the seller didn't do X. And it may be in the contract, but it's not a contractual way for the buyer to terminate and get their earnest money back. There's no written thing. It's one of those partial breaches here. So we want to address that. Okay. So in the contract, our 1 to 4 and all the other ones, they have a paragraph about default. What does default mean, right? It means a breach, typically, that is a major breach. And so if we have in paragraph 15 of the 1 to 4 contract, it says if the buyer fails to comply with this contract, buyer will be in default and seller may, and then they have a few options here, enforce specific performance, which is sue the buyer to fulfill their obligation to purchase a property at the terms agreed upon. Paragraph 2 says seek such other relief as may be provided by law, which means damages, lawsuit, maybe earnest money and more. It says or both. They can sue for performance and damages. It says or B, terminate the contract and receive the earnest money as liquidated damages. The next sentence is really big, thereby releasing both parties from the contract. So it's one of those things, if the seller says, I'll take the earnest money, that's all they can take. They can't go back later and sue the buyer for extra stuff. So sometimes the buyer, in the buyer's case, they may go, fine, take the earnest money because I'm in default. This is the damages are limited to just the earnest money because the other options could be more costly for both parties. And then, of course, it goes on to say if the seller fails to comply with this contract, seller will be in default. And buyer may, first one, and force specific performance means sue the seller to make sure they sell them the home on the terms agreed upon. Seek other relief like damages provided by law or both, or terminate the contract and receive their earnest money back. Thus, again, releasing parties. So again, if you terminate the contract, buyer receives their earnest money, they've given up their right to go sue the seller now for any additional damages because they've received their earnest money back. So it kind of limits there. They can do it all subject to attorney fees and charges, or if the earnest money is delivered to one party or the other, then the lawsuits basically are they've waived their right to move forward contractually. All right. That said, we're getting up to the terminations with the bases covered. We know that we just covered the termination, right? So when can a seller terminate the contract? We looked at paragraph 15. Well, it says when the buyer fails to perform. Okay. So seller now has a right. If the buyer is now in breach, a major breach, and they're in default per paragraph 15, we have one form. And the form only gives us two options. It says, buyer failed to deliver earnest money within time required under paragraph 5 of the contract and before the time the seller provided the notice to the buyer. Okay. So this period of time when the earnest money is due, 3 days, and the buyer doesn't deliver it by day 3, after the closing of the day on day 3, on day 4, the seller now has the right to terminate the contract, and demand the earnest money because the buyer is in default. This is a contractual term, but it's a breach that can be cured. Let's say that it's day 6 to day 7, they gave the buyer more time and the buyer deposits earnest money at that point in time. It's late, but now it's deposited. The seller now no longer has the right to terminate based on non-deposit because that breach was cured during the process. So it's one of those things where if the seller chooses to exercise this option, they've got to do it after day 3 and before the buyer deposits earnest money. Okay. So it's a small window of time, typically, unless the buyer never deposits it. And then the other one, of course, is it's wide open, saying identify the paragraph in the contract. And usually this comes down to a point where the buyer did not perform, like they didn't close. And typically number 2 comes down to they're supposed to close on May 15th and May 16th comes around and they didn't close. There's no extension in place. Seller knows buyer didn't close per the closing paragraph. Now we're demanding the earnest money. Okay, they are in default. Pretty straightforward for sellers. You only really have 2 ways. The buyer either doesn't perform and close like they said they would, or the buyer doesn't deposit earnest money. And then you have to make sure you jump on that. And I love the note below here. It says this notice is not an election of remedies, meaning it doesn't solve the earnest money issue. This only deals with the contract being terminated. This is a one-party notice. Seller goes based on the contract, based on the buyer's actions, and a notice that we are terminated in contract. Now, a separate form addresses the earnest money based on the contract. So just be aware of that. A lot of agents think that termination, no, this is the contract. Earnest money is being held by escrow. And now you have to come to an agreement, make a demand on it, and go down that route. Okay. Now, buyers there are a lot more options if we as agents put the options in the contract. Right? If we don't, there's actually not that many. So if we go here, we've got the very first part of the form, which is a buyer's termination, letting more people in, of the contract. So the very first one is the option period. We get a lot of questions around the option period, and I wanted to clear some of those up today. But the very first place in the contract and on this form for the buyer to have the right to terminate is number 1. The unrestricted right of a buyer to terminate the contract under paragraph 5 of the contract. Well, we're talking about the purchase contract, right? The 1 to 4. So let's go look at paragraph 5. What does it say? Paragraph 5 says, for a nominal consideration, the receipt of which the seller acknowledges and the buyer's agreement to pay the option fee within the time required, 3 days, seller grants buyer the unrestricted right to terminate the contract by giving notice of the termination to the seller within blank days, after. So you can be 3 days, 5 days, 7 days, whatever this period. So they have to deposit it within 3 days. In the option period that you're negotiating for, the amount of money you're putting down or giving as a non-refundable deposit, basically you're saying, hey, here's my option money. I'm buying 7 days to be able to terminate for any reason. Okay. It says after the effective date of this contract, the option period. It says notices under this paragraph must be given by 5 p.m. local time where the property is located by the date specified. It says if buyer gives notice of termination within the time prescribed, the option fee will not be refunded and escrow agent shall release any option fee remaining with the escrow agent to the seller, and any earnest money will be refunded to the buyer. So this unrestricted right period, the buyer is buying with their option money to terminate. This is where the questions come in, though. So that was our thing. So I wanted to highlight this, the next couple paragraphs to go along with it. So if the earnest money isn't deposited, if a buyer fails to deliver the earnest money within the time required, seller may terminate the contract or exercise seller's remedies under paragraph 15. We just covered that, okay? Or both by providing notice to the buyer before buyer delivers earnest money. Paragraph D says failure to timely deliver option fee. It says if no dollar amount is stated as the option fee, or if buyer fails to deliver the option fee within the time requires, the 3 days, buyer shall not have the unrestricted right to terminate the contract under paragraph 5. Okay, so buyer's got to deposit option money within the 3 days. with escrow to have the right. If they deposit on day 4, they no longer have the right to unrestricted right to terminate. Okay. A lot of our agents will misunderstand this. This is, when does the contract timeline begin? Well, it begins at execution. Okay. But execution is day 0. Day 1 of your timeline is the next day. So we have execution today, 5/3. The contract starts today, but day 1 for counting purposes starts tomorrow. Okay. Very important to think of. So when does a buyer have the right to do an inspection, right? It talks about the unrestricted right to terminate. We all do inspections during the option period, but they're not the same. The unrestricted right is for any reason. Inspections, they don't like it anymore. They just choose to go anywhere else. That is an option that they're buying. Okay. So the right to do inspection happens typically on day 1 of your counting. So it would start tomorrow if we have an executed contract today. Technically, it could start today, but typically your timeline starts the day after execution. So what if the buyer has not delivered option money? This comes up all the time. Buyer has 3 days to deliver the option money for the right to terminate for any reason. But their right to do an inspection starts at the beginning of the contract. It has nothing to do with the option period. The option period is just for them to use the inspection as a reason to terminate, in that period. So keep that in mind. All too many agents are telling agents they can't do an inspection until the option money is deposited. That is not true. The option money is only for the buyer to have the right to terminate without giving any reason if they want to. So keep that in mind. On sellers too, you have to give the buyers, agents, and buyers the right to do an inspection in some kind of reasonable manner. Okay. The second and third options on the way for a buyer to terminate have to do with financing. It all comes from the third-party financing addendum, right? So we have number 2 is buyer cannot obtain buyer approval in accordance with a third-party financing addendum to the contract. Okay, great. And we'll look at the third-party financing addendum. Now, if your buyer's not financing, they're doing it all cash, you don't have a third party typically, right? And so these 2 options wouldn't be available to your buyer. Now, if they are financing and you do include a third party financing, you have 2 outs there. And then the other out, number 3, would be the property does not satisfy property approval in accordance with a third party financing addendum to the contract. And then buyer, this is the second part, buyer has delivered to the seller's lender written statement setting forth the reasons for the lender's determination. I mean, admit, and I think I saw Diane. Got a question, Diane?
Yes. Actually, it's going back to your slide before that concerning the inspection before receiving the earnest money and the option.
Not earnest
fee.
money, option fee.
Option fee. So I have been in that position on more than one occasion that has happened to me, that they didn't deliver and then they want to terminate the contract when they never deposited the option fee in the first place.
Right.
So,
and they can't do it.
I know that's not what we're supposed to do, but the seller has to agree to allow the inspection. They can't just say, we want to inspect tomorrow and that be approved. So from my experience,
it has to be reasonable time. They can't be like at midnight and whatever. But yes, they have to allow an inspection because they've got an executed contract and the buyer has their right to do due diligence. And they can do an inspection anytime during the contract. They just typically do it during the option period.
Right.
The fact that they don't deposit option money, the buyer's waiving their right to terminate for any reason. Their inspection is a, they can still negotiate and do whatever, but they waive that unrestricted right. They've got to have a contractual reason to terminate after that. So does that make sense?
Yeah, I understand it.
Yeah.
What I was getting at is that I have experienced them wanting to getting the inspection the next day and then terminating before they even have deposited that. So in my experience and the way that I have said that I think best to handle that is not, I don't tell them we're not allowing, it's just inconvenience. I'm sorry, but it's inconvenient for the seller at this time.
I'm not advocating for that, but the ultimate thing is if they send you a termination after day 1, you're like, you don't have the right. You haven't deposited option money yet. So it's a matter of things. If you deposit option money, then you have your right to terminate. You know, it's semantics, but still, it's money that's owed to the seller. So, yep. Okay. Anyway, the second one's property. This is really important. A lot of agents miss this number 3. Andy, go ahead. Okay. Number 3. So in the third-party financing, page 2, a lot of people miss this. The paragraph A there goes in to say this is buyer approval. This is loan approval for the buyer's finances. So basically, are they credit worthy? Do they have the income to support it? Do they have basically the job, right? The history. They have the income, the past history, and the credit to get approved. So it says contract subject to buyer obtaining buyer approval. If buyer cannot obtain buyer approval, buyer may be given written notice to the seller within blank days after effective date of the contract. And the contract will terminate and the earnest money will be refunded to the buyer. Now, so that typically we see 14 days, 21 days, whatever it may be. And then the agents think that, 21 days are gone, the buyer can't terminate based on financing. That's not true. They can't terminate based on them getting an approval. They've got to have a buyer approval. There's still the second part of our approval, which is the property approval. So, but the buyer here, so if they get turned down by a lender, says buyer approval will be deemed to have been obtained. If they miss the 21 days and they haven't terminated based on buyer approval, they can no longer terminate on buyer approval after that point in time. And they've got to fulfill applying for the loan and providing all the stuff to the lender. Okay. Number 2, though, which is oftentimes missed, if buyer's lender determines, so this won't work on cash deals or hard money deals. This is buyer's lender determines that a property does not satisfy lender's underwriting requirements for the loan, including but not limited to appraisal, insurability, and lender required repair. Remember, those are negotiable, but still, if they're not done and lender won't lend on it, that is a property approval item. It says buyer not later than 3 days before closing, so all the way up to 3 days prior to closing, may terminate the contract by giving to seller the notice of termination, which we just saw, number 3 over there, a copy of the written statement from the lender setting forth the reasons why the property was not approved. And then, of course, if buyer does those 2 things, sends the termination 3 days prior to closing, and a letter from the lender saying that it didn't appraise, it could get insured, there's too many repairs, whatever it may be, then the buyer is entitled to their earnest money back and the contract's terminated. If they don't terminate under this paragraph, of course, then it's deemed to be obtained. So on A, if they don't terminate within 21 days or whatever days you put there, that goes away. And then the property approval goes away after, about 2 days before closing because they haven't terminated up to 3 days prior to closing. So it still exists for a buyer to terminate. If the lender says we can't loan on it because of these X factors, the appraisal amount, the insurance, or whatever. Andy, you still have a question, or you moving on? All right, number 4. This is interesting too. It says so. You've got first one was the unrestricted right to terminate. Number 2 and 3 have to do with buyer approval and then property approval. Number 4 again comes to another addendum. Did you add is the property in a property HOA? Mandatory membership in HOA. Did you include the form for that? The addendum for properties subject to mandatory membership. And a lot of our properties we sell are, but we have to add that to the contract. So it's a part of the contract. To utilize this, we have to go and says, well, paragraph A. Well, what does paragraph A in the addendum say? Well, it gives us choices, right? It says a subdivision, a current copy of the restrictions applying to subdivision, bylaws and rules, associations, and a resale certificate are all have to be delivered. So you have choices. Within so many days, they have to deliver to the buyer, the seller, or within so many days of the contract, buyer shall pay for that themselves, or buyer has received. In all of those cases, whether the seller is supposed to provide it, the buyer is supposed to pay for it, or they've already gotten it, buyer retains the right upon receiving the documents to terminate. Okay, so in the first one, pay for and delivers subdivision information to the buyer. If seller delivers information, buyer may terminate the contract within 3 days after buyer receives the information. Then it says, and money will be refunded to the buyer. So it doesn't have to give a reason. It said they got 3 days after receiving the information, whatever it is they left in there. Okay, fine. It says they have 3 days though. If they don't terminate in 3 days, then it goes away. Okay, it's their sole remedy in the contract at the time. Number 2 is where the buyer obtains them. Once again, 3 days after they receive the documents, they can terminate and get their earnest money back. And the last one, they've received them at execution. And then this is interesting. So buyers received that information returned. Buyer does or does not require an update. If buyer requires an updated resale certificate, seller at buyer's expense shall deliver it. And then the buyer would have 10 days to review an updated one. And then it says buyer may terminate there. So you have 3 days, 3 days, and 10 days, but it's an option that it doesn't say based on what they see. It says once they receive the documents about the HOA, here's this period of time that they can terminate based on their review of them. So it's another little option period only around the HOA documents. Okay. But it's specific to that. If you included this in your contract, most of you do, you're supposed to when you within an HOA, but here we go. The next opportunity is
I have a question about that, Marty.
Sure, Maria.
So what language do we use if our buyer wants to terminate based on the HOA? Like
right there, you just check number 4.
Yeah, the HOA.
Yes, number 4. You have the HOA addendum in there. There's no other language to add. You check number 4 within the 3-day period after receiving the documents. It says buyer elects to terminate under paragraph A of the addendum. Paragraph A is based on the choice you made. That's it. There's no language to say this is why. They're just terminating. As long as they do it within time. They've got 3 days. Yep.
Okay, great. Thank you.
Yeah, you're welcome. All right. Number 5 is it goes back to the contract. So we keep on going to addendum, contract, and so forth. So the 5th option says buyer elects to terminate under paragraph 7B2 of the contract. Okay. What does 7B2 say? Well, 7B2 comes down to seller disclosure, right? Again, this is one of those things when it comes to the seller is required, unless they're exempt, like a foreclosure or a estate sale, they've got to provide a seller disclosure. Listing agent is very important, okay? Because if you deliver the seller disclosure at mutual, at execution, right, the buyer has a timeline to review it and so forth, okay? Number 2, though, if they don't receive it at mutual, it says buyer has not received the notice within blank days after effective date, whatever that date is, seller shall deliver the notice to the buyer. If buyer does not receive the notice, buyer may terminate the contract at any time prior to closing, and the earnest money will be refunded to the buyer. So if you don't provide one and think you don't need to and you're not exempt, buyer retains the right to terminate all the way to closing, okay? Now, if the seller delivers the notice, buyer may terminate the contract for any reason within 7 days after buyer receives the notice of prior to closing. So think about this. So at mutual, you've got an option period of however much time you negotiated. You've got a financing period. You've got a property approval period. You've got an HOA period of 3 days. And now you've got a 7-day period to review your seller disclosure. And it says for any reason. Again, you don't have to give a reason why they're terminated. So for the seller, these are all windows that they want to try to shorten down as much as possible. For a buyer and buyer's agent, they need to be aware, all right, the clock is ticking. We have 7 days. This is our out for a seller disclosure. This is our out for property approval. This is our out for the option period. So there's not just the one. If we're being advocates for our clients, we're including these and pointing these things out so we understand where we're at in the clock. Okay. Number 6, a buyer elects to terminate under paragraph 3, again, back to another addendum. This isn't used as much, the addendum concerning the right to terminate due to lender's appraisal. Buyer has delivered a copy of the appraisal to the seller. So, okay, we've passed up top, we had the buyer approval, then we had the property approval, which dealt with appraisal. If we include this one, what does paragraph 3 say? It's the bottom part of it. It says, when the buyer wants an additional right to terminate, where they limit the amount of the appraisal. So we already know the lender won't lend on it more than it appraises. There's still an option for the buyer to pay a difference or whatever, This one says, in addition to the buyer's right to terminate under paragraph 2B of a third-party financing, buyer may terminate the contract within so many days after the effective date if the appraised value, according to the appraiser obtained by buyer's lender, is less than X, and then the buyer delivers. So they may put a limit, 10,000 less than asking price, 15,000, that they're willing to make up the difference. But if it comes in below that, this is an additional right to protect them, or maybe above it, whatever. Like I said, we don't use it very often, but it's specific to the appraisal amount that is different than, let's say, the purchase price. We give the right for the buyer to determine if they provide a copy of the appraisal to the seller. And again, that's a negotiated amount of days, but that's another period of time that you could add if you wanted to. And on the listing side, you want to say, why do you need an additional period? You already have to be in the third party. So do you want to protect your seller or not? All right, we're cruising through this. Number 7, in the buyer's termination, says buyer elects to terminate the contract under paragraph 6D. So we're going back to the 1 to 4 family or the purchase agreements to sort of find out what is 6D. 6D is the exception paragraph on title, right? So let's go back and look at 6D. So we have this big long paragraph, but it says basically buyer may object in writing to defects, exceptions, or encumbrances to title disclosed on the survey other than items, and it names them off above, disclosed in the commitment other than items 6A through 9 above, which we didn't cover that today, or which prohibit the following use or activity of. This line right here, most of the time we put residential use. It could be in-home business, whatever the things is that your buyer wants that to use the property for. If they find out that the title and the restrictions and the HOA docs or survey doesn't allow that type of use, they have a right to make an objection. Unlike other terminations, though, it says the buyer must take action here. They must be specific on this. So if they put residential use there, it's pretty straightforward, and it's not zoned or can't be used for housing. It's like commercial. Then they go, well, okay, clearly this is the reason we put an exception in there. This is why we want to. You want you to cure that. But said buyer must object the earlier of the closing date or blank days after buyer receives the commitment, title commitment, and the survey. Buyer's failure to object within the time allowed will constitute a buyer's waiver of right to object. So basically, they have to, within the negotiated number of days, say, hey, I said it has to be allowed to do this. If I don't object in time, then it doesn't matter. I lose my right to object. But if I object and say, this was a restriction on, I'm going to written objection that you said you must cure this thing during the cure period, the seller now the seller has 10 days, 15 days after the notice of objection to cure whatever it is the buyer's objected to that they put in here, like residential use or, During that cure period, it could extend closing to deal with the cure period. It automatically does that for the contract. If the seller at that point in time cannot cure it prior to closing, then it retains the right for the buyer to terminate. So this one's a much more subjective. It's if then you have an opportunity. There's a lot more for the buyer to do. I wouldn't rely on this way to get out of the contract for a buyer. Obviously, you can use it if it pertains to a specific use of the property. Excuse me. All right. Last one on there, of course, just like on the seller.
I have another question. I'm sorry for this one.
Sure.
Okay. So is it more prudent, do you think, to leave that section blank or to put something specific? Like, for instance, if my client wants to put in a swimming pool, I don't know, or in-home business. Most HOAs don't allow in-home business. No, but I mean, everybody works out of their homes, but they don't allow it. So what would be more prudent to deal with that?
Yeah, there's different opinions on that, but mostly Trek and other brokers say you should put whatever it is. You should be specific in there. You should put residential use. You should put if it's in-home business. If it's if you want to work from home, telecommute, put it in there. It's a factual statement, and it will add protection that the buyer can object if it's forbidden So I wouldn't leave it blank. You can put NA. That's a way of leaving it blank, but I would put something in there.
Okay.
Okay. And lastly, on paragraph 8 here for everybody, this is that one where let's say you had an attorney add language to your contract. Let's say that your buyer added a language to the contract or the seller added language, a contingency of some sort that's in the contract or an addendum we haven't covered yet that actually gives the buyer a specific right to terminate. Paragraph 8 is for that. You have to identify the paragraph in the contract or an attached addendum that really gives the buyer the right, and you have to address it and say that you're terminating based on that contractual term. We rarely see this, but it is. That's why it's there. It's for all those other cases where it is not your standard contract, where there's an additional addendum that relates to allowing the buyer to terminate. And again, the note at the bottom says this is not an election of remedies. This doesn't deal with earnest money. It just basically says I'm giving notice based on the contract and my right. The contract is terminated. Now we're going to deal with earnest money because it's being held by escrow. And of course, it says on both of the termination forms, it says consult an attorney before signing. TREC rules prohibit real estate license holders from giving legal advice. And so again, we're not attorneys, but we have to know our form. We have to, when we're writing offers, we understand kind of the timelines we're putting in and explaining to our buyers here's your option period. This is why we do this, why we have to pause this to give you the unrestricted right. But then we have other specific rights to terminate based on specific scenarios. Your financing, your appraisal, property condition, repairs, or title, or HOA docs, and so forth. We need to be on top of those. The one thing that I've seen too much in my career, especially in newer agents, is when they miss a timeline, and that's on us. We've got to be on top of our timeline so the buyer knows that hey, you have an opportunity right now. Today's at 5 o'clock. We've got to give notice. Where are we doing? Are we moving forward? You know that when we move forward, we waive that right to terminate in this regard. And then you go back forward and you go, well, but we have these other ones right here for specific reasons. It's that establishing credibility, but you're also performing your job. You're putting their interest above yours, saying, hey, here's our timeline. This is the day. Are we on track? So hopefully that was helpful along the lines, because we use these forms all the time. But it's like, I get comments or questions like, which one do I use? Well, go back into your contract and say, which one did you add to your contract? What's the situation? What's the specific contractual reason why the buyer has a right or the seller has a right to get out? And then don't conflate the fact that earnest money is not automatically delivered. Earnest money is dealt with in default, and both buyer and seller have multiple options to exercise. They can do performance, they can do damages, or they can do earnest money. And so it's not resolved yet. There's additional steps outside of the termination of the contract to deal with earnest money. Yvonne, go ahead.
Yes, good morning, everybody. I just have a question, Mari. What happens when the buyer at some point decide that they don't want to buy the property anymore and there are out of options on the contract? So they can still terminate it and give away the earnest money?
They put the power into the seller's hands, but the seller has a choice once the buyer's in default. So let's say the buyer, they don't have an option period, they don't have a financing, they've passed the property approval, they don't have title, they've got the seller disclosure, they passed all their times. They have no contractual way out. Their only option at that point in time is not to perform, which they're in default, which means the seller I can take your earnest money and we can terminate the contract and then release the buyer, basically. I can sue the buyer to make sure that they buy it. And sometimes that probably never happens. But they can also say, buyer, you took me time. I could sue you for damages. I could sue you for time off market and take your earnest money. So those are all the things where it's in the seller's control at that point in time to pursue those actions. The buyer's not off unless the seller goes, yeah, I agree to take your earnest money. So it's not the buyer terminating at that point in time. Yeah, it was like closing date is a week away and you know they're not going to close. Both parties can agree to say, all right, this is not going to be successful. Let's agree to terminate and give the money to the sellers. Okay. You can do that. Otherwise, you have to wait until closing date passes and then the buyer is truly in default. Then the seller can take actions. So it's Once you're out of options, it's really the other party's choice of what they do.
Okay, but in that case, let's say that both parties agree to terminate.
Mhm.
What is the section that we have to choose on the?
Yeah, that's a good question. Basically, you would just amend the contract at that point in time because you're still in contract. The
Mhm.
buyer doesn't have the right to terminate. The seller doesn't have the right to terminate, but they can agree to terminate through an amendment. So they would amend the contract. Buyer and seller agree. Contract is terminated, and then they would address the earnest. So
Okay.
you would, yeah. I know it comes up quite a bit, right? Because the buyer doesn't want to. The worst one is when the seller doesn't want to perform.
Yeah, that's what I was
and
gonna
the
ask.
buyer wants to, right?
Well, what
Andy?
happens then if the seller doesn't want to sell the property?
Yeah,
What else
buyer
is-
retains the
the
same
buyer-
rights. The buyer can take their money and go away. Buyer can sue the seller for, hey, I cost inspection, appraisal, you owe me this money. And or the buyer can say, no, I'm going to sue you, make you sell it to me. We had one of these cases up in Seattle, and it was one of those things where it was a shifting market like it is now. It was a very expensive house, and the seller did not want to close. And the buyer said, no, we want to buy this house. We got a good deal on it. We're not going to go anyway. The seller ended up paying the buyer $100,000 to walk away because they wanted to avoid a lawsuit because, they didn't want to sell anymore. So that's the remedy that they came up with to avoid it. So that in some cases, the seller, they have very few rights, but for them, it was worth it to buy the buyer out. Go away. Here, take $100,000, go buy something else.
Wow, that's a good one.
Yeah. And in some cases, I wish I was that buyer, right? That would have been nice.
Really?
Anyway, anything else? All right. Well, stay dry and have a great weekend, everybody.
Okay, thank you.
Appreciate you guys.
Class.
Thank you, Marie.
Thank you, Marty. Thank you.
Thank you very much.